Good evening, and thank you for joining us. We're delighted that we have a very good registration for this event, so we just want to give everyone an opportunity to join us, and then we'll begin within a minute or so. So please sit back, relax. Make sure you have a cup of coffee or tea, a mocktail or a cocktail, because this is an alumni event.
Yeah, I was wondering if our dry campus requirements extend to Zoom as well. Interesting legal question.
No, on Zoom, I think you are perfectly welcome to. You are welcome to have your beverage of choice. So, okay, I'm mindful of the time, and it looks like we have over 100 participants who have joined us, which is so fabulous. So allow me to welcome you. My name is Melanie Jacobs. I have the privilege of serving as the interim dean at the Michigan State University College of Law. And as much as that's a privilege, it's even more of a privilege to be colleagues with our three fabulous panelists tonight, Brian Kalt, Michael Lawrence, and Phil Pachillo, and I will give them a proper introduction momentarily, I promise. But let me first give some brief opening remarks, and then I promise we will turn to the meat of the program. We have not done something like this previously, hosting an alumni event as with a lecture component or conversation component, and we are just thrilled that more than 100 of you are joining us tonight. So this is fabulous, and we hope to do more of them, and we look forward to your feedback. This would not be possible without our extraordinary advancement team of Roxanne Kane and especially Sally Rice, who worked on all of the logistics for this webinar. So thank you, Sally. Thank you too to our IT department, especially Zoe Jackson, who helped with this. That has been extraordinary. I want to thank our DC Alumni Association, our DC branch of our Alumni Association, who are co-sponsoring this event. So thank you and welcome. So tonight we wanted to debrief the election a bit, and I have to say that November 3rd seems a bit like yesterday, and it also seems a bit like a year ago. But I also think that is partially due to pandemic time, which seems to run very differently than time ordinarily does. And certainly in these intervening 2 weeks, we, of course, have witnessed the declaration of a new president-elect Biden. Our current president, Trump, has not conceded the election and is pursuing legal action with respect to the election. And we know you have questions about this, and you submitted questions, and we're going to go through them. But tonight, what we hope is that we can have robust, nonpartisan discussion of these very, very important issues. And along those lines, I thought it would be useful to share with you a statement that the president of the American Bar Association issued just this week on Monday. So the president, Patricia Lee Riffo, issued the following. The American people have voted in record numbers. Every vote expresses a citizen's voice, and each vote legally cast must be counted. Our democracy is built upon the rule of law, which requires adhering to the laws and regulations established for elections. If there are any remaining legitimate concerns about the enforcement or implementation of those laws, courts provide the venue to rule independently and with deliberation on those claims. Once the courts have ruled, individuals have the right to disagree with those decisions, but that disagreement does not affect the validity of the court's decisions. That's the very essence of the rule of law. The rule of law also prescribes the peaceful transfer of power following an election. Our institutions of democracy, established by law, once again proved their brilliance even under the considerable strain of a pandemic and other challenges. The American public, volunteers, public servants, the judiciary, and lawyers all deserve our heartfelt appreciation for their work to ensure the electoral process remains fair and just across our nation. So our goal tonight is to talk more about these claims and lawsuits and the transition of power, hopefully demystify some of the conversation and add clarity. And to do that, we have a fabulous panel, as I mentioned, very dear colleagues of mine, experts in constitutional law, and also for our alums who are joining us, as you know, not only fabulous scholars, but fabulous people, tremendous teachers, and I am so delighted that Professors Kalt and Lawrence and Pachillo are with us this evening. Professor Brian Kalt is in his 21st year as a law professor at MSU. His scholarship focuses on the constitutional law of the presidency, especially the mechanisms for choosing, punishing, and removing presidents. His most recent books are Constitutional Cliffhangers, A Legal Guide for Presidents and Their Enemies, Yale Press in 2012, and Unable, The Law, Politics, and Limits of Section 4 of the 25th Amendment, Oxford Press in 2019. So, and I could also tell you, you could look for them on Amazon. Professor and past Foster Swift Professor of Constitutional Law, Michael Lawrence, also teaches courses on constitutional law. His current research interests are in the field of constitutional law and racial justice. His scholarly articles and op-eds have appeared in numerous law reviews and major newspapers, and he's participated in high-profile amicus curiae briefs before the U.S. Supreme Court and other federal courts. He is also an author, and his book, Radicals in Their Own Time, 400 Years of Struggle for Liberty and Equal Justice in America, was published by Cambridge University Press. And then he has a second book, Model Problems and Outstanding Answers on Constitutional Law, with another of our colleagues, Kevin Saunders, published by Oxford. You can look for those titles too. And then our third panelist tonight, Professor Phil Pachillo, has been teaching at MSU Law since 2010. And he teaches courses in civil procedure, constitutional litigation, evidence, and professional responsibility. And I think it speaks volumes to his personality when I share with you that in his bio, he put his favorite part of working at MSU Law is participating in alumni events, whether in person or remotely. So welcome to all of you. Welcome to our fabulous panelists. And we are going to get started with your questions. As you heard from their bios, all of our panelists have experience and expertise, rather, in constitutional law issues with slightly different foci. And so they went through the questions and look and decided who might address what, although we also thought that for a good, robust conversation, even if one participant answered the question, we could also then have feedback and additional information from the other two. So I'm going to address the first question to Professor Pachillo. What federal constitutional claims have the Trump campaign raised in Georgia and Pennsylvania? And then could those claims be considered by the US Supreme Court? So could those claims reach the US Supreme Court?
Thank you very much, Dean. Great to see on the participants list so many familiar names. Thanks for being with us tonight. Okay, so basically what we're seeing in Pennsylvania and what we're seeing in Georgia, and I think as well as of today, Nevada, we're seeing essentially two kinds of federal constitutional claims brought by the Trump campaign in order to trigger either an order that the popular vote in the state not be recognized, or that there be some kind of audit of the votes, or that there be some kind of a recount. So remedy, that's going to be a tough one to speculate on what can happen. I think the The campaign doesn't really know what to ask for. I don't think the courts understand what they can grant in terms of relief. But just to focus on the claims for a moment, I'm going to put them in two categories and then have Professors Kalt and Lawrence explain what's really going on. The first one is based on, and I'm going to share the screen because I know everybody here loves Zoom, and I don't want to stray outside of the classroom too much. But I'm going to focus. Can everyone see Article 2, Section 1 on the screen?
Yep.
Great. So I'm going to focus here. So this is Section 1 of Article 2. The executive power shall be vested in a president of the United States and holds his office for 4 years. And the critical provision is here. Each state shall appoint in such manner as the legislature thereof may direct a number of electors equal to the whole number of senators and representatives, etc. So the key term here is as the legislature may direct. And the reason why this is so important is because what we've been seeing, and what was at issue in Bush versus Gore 20 years ago, at least partially, and what's at play now in many of the states where there are election challenges brought by the Trump campaign and others. The argument is that the will of the state legislature, how the legislature had prescribed statutorily for the election to be conducted, there's been some kind of significant departure. For example, in Pennsylvania, we've seen arguments to the effect that the state election administrators had allowed for ballots that hadn't been submitted by election day. Under the statute, strictly applied, they should not be counted, but extra time was given administratively and in guidance provided to the precincts that provided that that we have on the ballot envelope a postmark of election day, then that ballot can be turned in several days after. Another thing we saw or we've been seeing in Georgia is, and this was pursuant to the efforts of largely of Stacey Abrams, who had her own election dispute a couple of years ago. There was some effort to make it easier for individuals to vote, arguably outside the purview of what Georgia strictly allows. And so, but back to Pennsylvania for a second. I don't want to leave Pennsylvania too quickly. So the argument would be that anytime ballots are counted and considered legitimate and valid in a manner that does not comport with the statute, but even if it would comport with administrative guidance, even if it would comport with a judicial ruling, that ballot should not count as valid and should not count toward the candidate, whomever the individual had voted for. A late ballot is a late ballot. And just the fact that a Pennsylvania court sees it differently doesn't matter, because that's not what the Pennsylvania legislature said. The fact that the Secretary of State of Pennsylvania, that's not what the legislature said. So the first basic constitutional claim would be that at the very least, votes must be counted through norms that have been enacted and prescribed by the legislature. Any deviation from that can't be tolerated. Secondly, the second category of federal constitutional claim that might reach the Supreme Court would fall into the category of equal protection. And it was equal protection that was the basis in Bush versus Gore for stopping the recount that had been ordered by the Florida Supreme Court 20 years ago. So the argument here is that the way the standard for accepting or rejecting a ballot as legitimate cannot vary in different parts of the state. What you had in Bush versus Gore arguably was ballots, the validity of a ballot was being determined by different standards that were being applied differently depending upon what county you were from. And sometimes even within the same county, different standards were being applied. And the Supreme Court held that that is a violation of equal protection. I mean, it didn't hold that in Bush versus Gore. It had held that previously, but it was applied. The principle was applied to say that we can't tolerate a recount regime under which the same ballot or the different standards are being applied to determine whether ballots in different places are being sustained for their validity. So if I could, let me go to, I'm just going to go to the map for a second, so you might have a situation where in Pennsylvania, if you're from the Pittsburgh area, so I'll just mark that here, what the Trump campaign is arguing is that in the Pittsburgh area and then also in the Philadelphia area, what you've had lax enforcement of policies that I should have actually made those blue in retrospect, because these areas were significant sources of votes for Joe Biden. So what was happening was that restrictions on mail-in voting, and this is aside from the timing aspect, such as the mail-in vote would have to have a signature. The mail-in ballot would have to be secured in a secrecy envelope. What was happening in those parts of the state to a significant degree was that requirements such as those for mail-in ballots were not being enforced. So a voter who sends in a mail-in ballot who didn't sign it, their vote might be counted after all. A voter who didn't place the ballot in the secrecy envelope, their vote might be counted after all because the requirement wasn't being enforced. Other ways of handling a non-conforming ballot were some voters were given a chance to cure. So they were actually contacted and said, you didn't sign your ballot, you're going to have to come and take care of that. And so they would sign the ballot and all would be remedied. So compare that to someone who's voting in the middle of the state. This is the middle district of Pennsylvania, somebody here. That person didn't comply with the requirements, didn't sign their ballot, and because enforcement was more rigorous in that part of the state, that person's vote wouldn't count. Nor would that person be given a chance to cure, because again, cure would have to be part of the statute, and there was administrative guidance in Pennsylvania to the effect that that cure should be permissible. So in some parts of the state, the lax enforcement of mail-in ballot standards. Other parts of the state, rigorous enforcement of mail-in ballot standards. In some parts of the state, you had chance to cure offered to the voter. Other parts of the state, no chance to cure because that's not something the voter is entitled to. So what's the upshot? The upshot is if you're in this part of the state or this part of the state, your ballot would be counted and your vote would be considered part of the count. If you're from this part of the state, on the other hand, your vote wouldn't count. And you wouldn't be given a chance to cure. So the end result, you have different standards being applied in different parts of the state. If only the voter here had lived here, that person's vote may have counted and been tabulated because the restriction that wasn't complied with would have been overlooked or there would have been a chance to cure. So the argument from the Trump campaign's perspective is that there is an equal protection violation that's being committed in the different application of these standards across state lines, across counties or different parts of the state. And so that amounts to equal protection. That's the federal constitutional violation. And could this reach the Supreme Court? Sure, it could. The Article 2 argument might go to the Supreme Court. The equal protection argument might go to the Supreme Court. What makes me think it wouldn't happen, and I'll defer to my colleagues on this, what makes me think it wouldn't happen is the margin of victory for Trump is now around 80,000 votes in Pennsylvania. That's an awfully difficult burden to overcome. And the Trump campaign would have to prove not only do we have constitutional violations, but there's some remedy that could be effectuated by the federal courts, which could lead to could lead to a significant gain in votes for Trump or a loss of votes for Biden, which might make it close enough to make the recount or the audit or whatever other remedy is prescribed worth it. I'll stop there.
So yes, I would like to ask Professors Kalt and Lawrence to weigh in, and then I have a follow-up question to that.
So what I would add to that is there is a big difference between what the Supreme Court said in 2000, where time was of the essence. They were saying you need a statewide uniform recount standard. We don't have one. We only have a couple days left. Let's just end this. That's very different from what we'd be saying now. There, the result hung in the balance. Here, as Phil just said, the result really probably doesn't hang in the balance because the number of ballots at issue here, and I see the question in the chat, the number of ballots at issue here are not that large, not enough to swing the election. And I also just want to comment that I think it's interesting, and we'll talk about this more later, I'm sure, but there's a big disconnect between what President Trump has been tweeting and what his lawyers have been arguing in court. And President Trump hasn't been tweeting a lot about equal protection violations. He has a little bit, but he's mostly been talking about fraud. And that's not what has been litigated in court. They're not saying there's 100,000 fraudulent ballots that need to be thrown out. They're saying there are these ballots that were treated differently and we need to treat them the same. And if you think of that remedially, one way to treat them the same is to let the people whose votes didn't count, right? Count more votes instead of throwing votes out, which all other things being equal, we would prefer as a remedy. And even in the red parts of the state, most of those mail-in ballots were for Biden, if you just look at how those numbers came in. So the remedy might not cure the injury, and if they can't argue that giving them what they're asking for would cure their injury, in fact, they might not even have standing. So I would expect that if this does go up to the Supreme Court, it would be on an issue like that. Is there even a case here without even getting to the merits?
And I would add as well, and that's responsive to the chat too, just the scale of the sorts of numbers of votes that we're talking about here is not enough to make a difference, to change the outcome. Another difference from this case and Bush v. Gore, we're talking about a recount in that case, whereas these are the original ballots and so forth. So that could be a factual difference that can be important. As Professor Kalt mentioned, really so many of the claims, what the president is talking about is fraud and different claimed problems with observers and transparency and so forth. And what are the numbers? 23 of 24, 24 of 25 of those cases have come out against him so far. They really just those claims just are. The problem is for those claims and the sorts of tweets and whatnot is that once you get into a court of law, there are rules of evidence, and I mean, and a tweet is not a very solid piece of evidence, and so once you're subjected to those evidentiary rules and so forth, we see that the claims just don't hold up.
Thank you all for those comments. And so relatedly, and you may have already shared this on your screen, Professor Pachillo, but something that we had another question about whether the state legislature has the authority to disregard the results of the vote for electors and choose electors themselves, right? There's this back and forth of what the electors will do, or could there be new electors? And I wondered if you could help us understand more about that.
Sure. So Yeah, one thing that seems to be part of the Trump campaign strategy, and even if it's not, there is some degree of speculation by commentators that what the campaign is really trying to do is convince the state legislatures in the states where the battles are underway right now, namely Georgia, Pennsylvania, Michigan, Arizona. All of these states are governed by both House Republican state legislatures. I think I have that right. I'm pretty sure. Definitely Georgia, Pennsylvania, Michigan. I think Arizona as well.
Wisconsin.
So, how am I doing, Brian?
I think that's right, but you
Yeah.
keep talking. I'll pull up my chart.
Okay. So, so the argument would be that what the Trump campaign is really trying to do is to convince the state legislatures that they should take the power back. That with all of these federal constitutional violations, all of these apparent procedural irregularities, allegations of fraud, what the individual state legislatures, where he lost in the popular vote as currently counted, what they should do is they should take the power back and say, we are going to disregard the popular vote and we are going to award the state's electoral votes to Donald Trump. Do they have the authority to do that? I think there are two sides of the argument. The first side is that once, again, just going back to Article 2 for a second, I'm hoping that everyone sees Article 2 on the screen. Again, each state shall appoint in such manner as the legislature thereof may direct. In the old days, it was rather common for the state legislature to choose the electors. The people of the state weren't really involved in the process. That started to come about more at the end of the 19th century, the popular vote. We in this state, we select our electors through popular vote. That wasn't always the case, but certainly is the case now. But it was often the case that the legislature would do it directly. But there is some precedent, and the precedent was cited most recently in Bush versus Gore, where it was recognized that the legislature at any point could determine that the election failed and that the legislature has the authority to make that choice itself. I'm going to go from the Constitution to a federal statute. This is Title 3 of the U.S. Code, Section 2. Whenever any state has held an election for the purpose of choosing electors and has failed to make a choice on the day prescribed by law, the electors may be appointed on a subsequent day in such a manner as the legislature of such state may direct. So taking the inherent power, or at least the power granted by Article 2 to the legislature to direct the manner of choosing electors, combined with the statute, the argument would be the legislature, regardless of how the popular vote turned out, if the legislature has concerns, the legislature can act unilaterally and enact and choose the electors on its own. A counter argument to that approach to interpreting Article 2 and Section 2 of Title 3 is that the state legislature wouldn't have the authority to make a unilateral decision about who the state's electors will be once election day has occurred, because we have in Section 1 of this same title, the electors of president and vice president shall be appointed in each state on the Tuesday next after the first Monday in November in every fourth year succeeding every election of a president and vice president. That's why we vote on the first Tuesday after the first Monday. And that's why we did it on November 3rd, right? So the argument is, yes, the legislature has the authority, if it so chooses, to choose the electors on its own. It doesn't have to give the people a voice in that process. But once it does, and once the people vote, the legislature's role in the process ceases to be, absent an actual failure. And so when Section 2 refers to fail to make a choice, We're talking about some cataclysmic event has happened that has prevented a popular vote even from taking place. For example, you can imagine how there might be an earthquake, it might be weather related. There might be a dirty bomb that goes off and everyone stays home. So there never really was an election. At that point, the legislature might say, okay, we tried to have a popular, we tried to give effect to the popular will. It didn't work out. Now we're going to make the choice because time is running out and a choice needs to be made. So, based upon what the Supreme Court has said, this is something the legislature can choose for itself at any point, even now. So the Michigan legislature could very well say, all these allegations of fraud coming out of Detroit, all of these allegations of improprieties, we take them seriously. We're making the choice. The state's electoral votes go to Donald Trump. My goal here tonight is not to give any of you a heart attack or anxiety. We're here to discuss the strictly legal issue. Politically, just because the state legislatures can do it legally doesn't mean they're going to have the political will. I think it would be an act of political suicide for any legislature to do this. But that's at least where the legal debate lies in terms of what state legislatures can do.
I guess just to jump onto that, a couple points to add on that is first of all, the Republican leaders of those 4 states or so, I think it's the Pennsylvania, Wisconsin, Michigan, and Arizona, have said that they are not inclined to do that. So that's good news at this point. They've said that they are going to adhere to the popular vote count. So that's a good thing. Secondly, there's another aspect to this that the Supreme Court has weighed in actually years ago in a sort of in a related sense, but it's been a discussion in academic circles and scholarly circles, is that when we use the word legislature and consider the word legislature in this context, it also requires the participation of the governor. And to the extent that any sort of movement coming out of a legislature can't be done unilaterally by a legislature per se, but that it has to involve the participation of the state's governor too, who of course is a participant in lawmaking, in legislation. So that is actually a counter argument, and there's some precedent in the United States Supreme Court that would support that interpretation.
I just want to add briefly, there is this 3 U.S.C. Section 2 process, and it does seem like that's what the Trump campaign was going for, not to win the certification, not to get the vote count to come out in their favor, but just to throw enough doubt into it that there wouldn't be a certification. That would open the door to the legislature to step in under 3 U.S.C. 2. But that would not prevent, even if the governor isn't involved in that process, and I looked it up, all 4 of those states do have Republican legislatures, and other than Georgia and Arizona, they have Republican governors, but Michigan and Pennsylvania have Democratic governors. The governor signs off on the certification. So if the legislature isn't in charge of the certification, so if a court isn't stopping the certification and the governor signs off on that certification, the legislature can do whatever it wants, but that certification with the governor's signature on it is what Congress, under the Electoral Count Act, is supposed to count. And we'll talk about this later too. I'm sure there could be some confusion in that congressional count, but if they're not preventing the actual certification from happening, there's really not much of a window there for the legislature to step in.
Thank you. Last night, the 4 of us were going back and forth by email, a little bit different issue than choosing electors, but there was late breaking news out of Wayne County, right, where Detroit is located, that that the election was not going to be certified, or that the county electors, right, wouldn't certify the vote. And we were sharing some news stories back and forth. And I think by the time that we all looked at email, the story had changed yet again. But could one of you give us a little more information on what that process was about and how it fits with some of these other issues that you've been discussing. I don't know if maybe Professor Kalt or Lawrence wants to take this one first.
I could take it. So the process for certifying the ballot is done in increasing levels of statewide-ness. They start at the precinct level, go up to the county level, then the state level. So the counties were supposed to certify their votes and send that to the state. And each county canvassing board is has a partisan balance, and they generally are just, this is not dealing with recount. This is reconciling. This is like balancing your checkbook, making sure the numbers add up, that the ballots are all where they're supposed to be. And there's really two separate issues. There's certifying the winner and certifying the numbers. This is about certifying the numbers. And so there were some issues. There were some precincts where the number of votes on one count didn't balance with the number of votes on another count. There were plenty of places in Detroit where that was an issue. It was a much bigger problem 4 years ago. They improved. It's still a problem now. It was also a problem in Livonia. It was also a problem in some other places. And ordinarily what they would do is they would certify it as best they can, send what they've got to the state. If they say that they can't do it, then the state comes in and the state takes over and says, well, we'll try and balance the checkbook. We'll figure this out. But the reason it was so controversial that initially Wayne County party line vote didn't certify their total, was going to have the state do it, was that the discrepancies were not significant in numbers. So they were going to not count all of these votes because of a problem with a tiny one, right? Like if you're balancing your checkbook and you can't find that missing nickel, that's not going to stop you from going forward with your banking, right? You can still write checks. You'll find that nickel one of these days, but your balance is in thousands of dollars. You're okay proceeding, and it shouldn't stop the state from certifying the totals, and it certainly shouldn't stop the state from certifying the winner. And once it became clear that this was that was pointless and it was one-sided to pick on Detroit and not Livonia, for instance, then they reversed themselves.
Right, and I just add too that the numbers just were not that historically this has always been a pretty much pro forma sort of activity, and as Professor Kalt was saying, just even with the discrepancies and of course the real one of the real problems here is that discrepancy between Detroit and Livonia and the racial compositions of those two communities, with Detroit being primarily black and Livonia being primarily white, and the sort of discrepancy that where the those who were voting against certification at first were focusing on Detroit but not on Livonia. So that was hugely problematic.
I see there's a question.
Sorry. Yeah.
Chat about county board members being elected or appointed, which is relevant to this discussion. And I don't know if you know that answer.
I don't know.
So we are not sure right now.
Yeah, I don't know. I can try and find it real quick while some other questions get answered.
One thing I wanted to mention about the situation in Detroit, a lot of the allegations that the Trump campaign had been leveling had been based upon observations of Republican poll observers that had allegedly, according to their affidavits, had alleged that there were various irregularities, apparent vote filling, the prevention of monitors from being in certain places. And what surprised me was how summarily those allegations were dismissed by Judge Kenny in Detroit, Judge Tim Kenny. And one thing that he noted, which I thought was interesting, was that Michigan law doesn't, there is a provision for monitors being present, but not necessarily that monitors from both parties be represented. So I think that was a key allegation that had been made, was that Republicans were being excluded because they were Republican poll monitors. But the judge ruled that there isn't a requirement that there be a Republican to observe each act of reviewing the ballot for validity. So that was interesting how, and that was just one problem with what was being alleged, but it was interesting how quickly Judge Kenney disposed of the arguments that the Trump campaign had been making about what had happened in Detroit. Finding that the explanation offered by the Wayne County officials was more convincing than what was being alleged, and as a result, just wasn't even close to being willing to grant an injunction to order an audit or any other form of relief. And the Court of Appeals hasn't intervened, and the Michigan Supreme Court's not going to intervene. So I think on anything that happened out of the TCF Center, anything that may have been observed there, I don't think that's going to be the basis for anything, especially when you consider the gap that Trump faces in Michigan, which is in the neighborhood of 150,000 votes. So I just wanted to bring that into the equation.
So prior to 1963, the canvassing boards were elected, but since then they've been appointed by county commissions primarily, and the county commissions, the govern each county, get the names. They're nominated by the local political parties themselves. So the Democratic Party, the Wayne County Democratic Party, sends some names forward, and then the Republican Party does the same, and the county commission signs off on that and formally appoints those people.
Thank you. You researched that quickly. So thank you so much for all of this. We had a question too raised about the controversy with the Dominion voting systems and the Smartmatic, I hope I'm saying that right, the Smartmatic software. And then, that brings us back to when will the Kraken be released?
So am I going to release the Kraken, gentlemen? I'm happy to.
I believe you are.
Yeah. Okay. So it seems like what's the allegation here, which is being leveled by attorneys Sidney Powell, who has been representing General Michael Flynn in conjunction with his effort to vacate his guilty plea on charges of lying to the FBI at the early part of his tenure as national security advisor, and by Lynn Wood, attorney who he had recently represented some of the Covington, the youngsters from Covington in their controversy when they sued the various media networks. So both of these attorneys have somewhat of a national profile, and they are making very clear that, and without disclosing their evidence, but they're saying that they have overwhelming evidence that there is some foreign source that has been able to hack into and reprogram the Smartmatic software that drives many of the Dominion voting machines throughout the nation. In fact, this has been going on for years, and it's been happening throughout the world, if their allegations are to be believed. So far, they haven't disclosed the particulars of the evidence. They're just saying that it's coming. So, and the way they're speaking, they are more than confident that once the evidence is out there, we're going to see a lot of votes, upwards of hundreds of thousands, if not millions of votes, shifting to Donald Trump from Joe Biden. Again, my point here is not to give anyone a heart attack, not to create any further anxiety. Our goal is to simply discuss what's been happening in terms of at least what's out there in the Twitterverse.
So I didn't know if Professors Lawrence or Kalt wanted to add to that. I had a few additional questions, somewhat related perhaps, and then one in the chat that I wanted to raise with you.
No, well, let's move on and
okay,
get as many questions as we can.
We had a question ahead of time, and then there's one that's a little bit different in the chat. With respect to, and I'll direct this to you, Professor Kalt, given the evidence so far, and this builds on what Professor Pachillo was just saying, that there's allegations, but we haven't necessarily seen the proof behind it. So given publicly available evidence that has emerged so far in each of the lawsuits seeking to challenge the election results or illegal voting, vote counting, is there a federal rule of civil procedure, Rule 11, violation or a potential problem for any of the attorneys filing? And maybe just in case we have anyone who doesn't remember Rule 11, you want to just give a quick.
Sure. Well, that's the one about frivolous complaints, and I think that the issue that faces the Trump legal effort is not that the attorneys are going to be subject to Rule 11 sanctions nearly as much as that they're going to avoid getting Rule 11 sanctions. And as a result, they're not going to put into their lawsuits a lot of the claims that have been made on Twitter by the president or by these other folks talking about these allegations. I'm always reminded of an old Stephen Colbert line when he played his character on the Colbert Report. He said some outrageous thing and he looked into the camera and he says, "Now I can't prove it, but I can say it." And that works on Twitter, but obviously it doesn't work in court. And so you've seen that. You've seen when they go into court, they'll say, we're not actually presenting evidence of fraud. We're not saying that these ballots were fraudulent, just that people weren't able to observe close up enough or something like that. The attorneys, by and large, have been scaling back those claims for that reason, I think, to avoid those sorts of sanctions. And so I take that as a great indication that the system is working the way it's supposed to, that the court is relying on the possibility of sanctions and other mechanisms that we have for getting to the truth in these cases to really separate out claims that you can make on Twitter from claims that actually can prove a legal case.
It's been interesting on that question to observe what's happened too within the legal profession. There's been some internally real criticism of those firms. A large firm, Jones Day in particular, I think, is a large firm that's represented President Trump and the campaign as well. And they've come in for a lot of criticism in the legal profession for representing these claims, and so have actually requested, as have other firms and other individuals, other lawyers, requested to be released from the cases and so forth. So that's been an interesting thing to observe with that, sort of related to that Rule 11 question.
And then relatedly, there was a Rule 9 question, how Federal Rule of Civil Procedure 9 impacts the claims being made. Particularly, this was related to Rudy Giuliani's representations that the complaint contained allegations of fraud. So Professor Pachillo, you're our Civ Pro guy.
What's interesting is that, he was making reference to fraud in Pennsylvania, and it really wasn't helpful in conjunction with the constitutional arguments that he was raising. Again, this is federal court, so the claims would have to be based on federal law. And as we were discussing earlier, the federal law claims would sound in Article 2, right, that the election was not conducted in the manner prescribed by the legislature, and equal protection, that standards in different parts of the state are being applied, different standards are being applied to determine the validity of ballots. So the fraud aspect just isn't helpful. But yeah, to the extent that fraud is being alleged, under Rule 9, it would have to be alleged with particularity. And so far, that the complaints that I've seen at least haven't risen to that standard. But that's something you see often in federal court, even in state courts that have Rule 9 counterparts. You often see complaints fail When I was in practice, I defended claims of securities fraud, so there was a lot of Rule 9 dismissal motions that would be brought to respond to those claims. And so it's very common for federal courts to dismiss allegations of fraud on the basis that the pleader failed to plead the facts with particularity, and very rare to see anything along the lines of a Rule 11 sanction. So I don't think we're going to see anything like that with respect to what's been filed by the Trump campaign in any of these actions. I mean, sometimes the pleading could have been a lot better. The Giuliani arguments, I think if the Trump campaign, I mean, if I were taking charge of the Trump campaign tomorrow, I think the first thing I do is relieve Rudy Giuliani of duty and put in someone who can really focus on the constitutional arguments. So, but yeah, in terms of Rule 11 sanctions, I don't see anything like that happening.
So thank you. And I recognize that there are questions in chat, and I am trying to intersperse them, but just so that people don't feel that we're intentionally ignoring them, we had asked for questions ahead of time and had about 4 pages of questions ahead of time. So I'm trying to do my best to manage the questions that we already had, with some coming in, so it's not to intentionally slight you, and my apologies if we don't get to your question. So one of the questions, and I think perhaps this is really at the heart of the questions we've had about lawsuits and so forth, is, are there legitimate paths to President Trump remaining president? Right, I think that's really at the heart of what people are asking about ballot counting, absentee ballots, claims, and so forth. Does it seem, I'm going to ask you, Professor Kalt, does it seem that there is a path for President Trump to remain in office?
The most important thing to say about that is that the only way he remains as president is if one way or the other he wins the election. And if he can't reverse the results in enough states to get to 270 electoral votes, and it looks like that's just not going to happen, then his only possibility is preventing Biden from getting to 270 votes. Throwing enough doubt into it that no one has a majority, that Congress, when it counts the electoral votes on January 6th, says no one has 270, to say that you need 270 and not just a majority of the votes that do get cast, and then that as a result the election is thrown into the House of Representatives. And the procedure for that is the House of Representatives votes, each state gets 1 vote, and you need 26 states, while the Republicans will control more than half of the state delegations. So if he has a path to remaining president, legally it has to be that. It has to be reversing the result, not going to happen. Preventing a result, probably also not going to happen. But if it did, then he would win in the contingent election in the House.
And
although, I should just say the contingent election, if it goes to that, there are a lot of other problems that we don't have time to get into here. But if anyone wants to email me about that, I'll tell you. I don't want to alarm anyone, but all hell would break loose for a lot of other reasons than just the election results. I'll just put it at that.
And it seems that based on the lawsuits so far and those efforts that would be necessary to take states away from President-elect Biden, that's very, very unlikely to happen. I mean, that basically when on January 20th, there will be an inauguration. President-elect Biden will become president, and Vice President-elect Harris will become vice president, and there will be a lot of noise in between now and then, but that seems very, I won't say very absolutely certain, but very, very, very likely to happen.
So that really is going back to the beginning here, right? The hallmark of our system of government is this orderly transition. I know many of you on this Zoom, and you know I have a son because I bore you by talking about him all the time. And When I used to drive him to daycare when he was about a year old, it was a different presidential election, and I used to like to just regale him with, the three branches of government and so forth, right? Because that seemed better than gaga goo goo. And, so I would talk about this notion of the transition. It's interesting, right, to think that there's this period between the election and Inauguration Day where we lead up to this orderly transition. We've seen President-elect Biden give information about his chief of staff, about other important appointments. He's going to start recommending cabinet appointments soon, that we have this time. So we know that the transition time is so critical so that we don't have gaps, right? So that on January 20th and January 21st, it doesn't feel like there's been a change. So Professor Lawrence, I wonder if I could ask you, can we have a little more insight into the requirements and rules related to the authorizing or authorization of access to funds for the transition team? You were just talking about the fact that we'll have President Biden and Harris. So what's so important about having access to funding for the transition team so that we can have this clear transition, an easy transition of power?
Well, from a practical standpoint, the funding, the resources, the office space, and critically access to briefing and so forth. And of course, with this election, we have yet another first-time event, and that's when the transition has not been authorized immediately after the election, or even immediately after the president was called by the major networks. Not that there's any sort of legal bearing on that, but traditionally and under normal sort of circumstances, once a person is called by the networks or generally accepted to be the president-elect, then it's a very prompt and swift process under the Presidential Transition Act, which was originally passed in 1963, which requires that the GSA administrator, General Services administrator, ascertain, quote unquote, whether a new president and vice president have been elected. And so ascertainment in normal times, in recent times, since 1963, has involved a very prompt sort of announcement and arrangement by the GSA administrator for the president-elect to get access to all of these resources and briefings and so forth. But of course, now that has not happened, where Emily Murphy, the GSA administrator, has refused so far to do that, even after the election, even as President-elect Biden has assembled what looks to be 306 electoral votes, well over the 270 which would be required. So there will be really what they are saying, and the GSA says in a statement on Saturday, it ascertains the apparent successful candidate once a winner is clear based on the process laid out in the Constitution. Well, there's really not a process laid out in the Constitution other than January 20th will be the inauguration, and also the Electoral College when that happens. And so once the electors vote in December, I guess it's December 14th, it's going to be pretty hard for them to claim if we have to wait that long. Certainly, we hope that there will not, that Emily Murphy will not hold out that long. But it's going to be very hard to claim after that point that there cannot be this transition that would begin. And that would still leave more than a month formally. But we see that President-elect Biden is working around the sorts of roadblocks and so forth, meeting with various officials and former national security folks and so forth. So he's getting briefings in his own way. But the sad thing is, just with COVID and the response to this horrible plague that we're all suffering from right now, that the government cannot be more coordinated between the departing administration and the incoming administration, because that's really what's suffering here.
Perhaps this is more like a bad final exam hypothetical, but more than one person asked it when we asked for questions ahead of time. So I thought I would pose it to you and see what you all think. So what happens if President Trump refuses to go? right? If he doesn't pack his things and get ready to leave, what happens on January 20th? Could we have a situation where President Biden is trying to move into the White House, but President Trump is still there in the Oval? As I say, maybe it's, abstract exam question, but several people asked.
Well, I mean, it is a real question. I mean, if he just fails to leave, what happens? And there are discussions among Secret Service agents and ex-service Secret Service agents. We start to hear in the press about that. There's about what would happen. There's maybe two choices: whether the military would step in or whether the Secret Service. I think. Among most folks who are thinking about this, think that it should be the Secret Service to keep the military out of civilian affairs, and it would be better for the Secret Service to be involved in that. But the Secret Service would come and in quoting Robert Chesney, a national security law professor at the University of Texas, the Secret Service would come and escort him out as a trespasser. And we heard Justice. Or rather, the campaign manager, I think, or campaign official in the Biden campaign, saying roughly the same thing, that the U.S. government is perfectly capable of removing trespassers from the White House. So come January 20th at noon, if he's there, he's a trespasser, and he is breaking the law, and he can be removed.
I think it's interesting to consider what this shows us about how much of what we always sort of got used to or imagined as being a matter of law was actually always just a matter of norms. Announcing the transition. The networks announcing it, it's not that the networks have special power, it's that they're looking at the numbers that the states are reporting, the unofficial numbers, and we just see what the numbers are and proceed accordingly. But that's a norm. And the law rests on that norm, right? Ascertainment rests on that norm. The law is a little stronger with regard to what happens at noon on January 20th, though. The 20th Amendment very clearly says in Section 1 that at noon on January 20th, the term is over. And if you are Joe Biden and you have Congress on January 6th counting the votes that the Electoral College cast on December 14th, sent to Washington on December 23rd. It's not a secret how they voted. We all know. And then Congress officially declares on January 6th that Biden is the president. Then President Trump would have no legal basis to claim that he was still president at that point, because term is over. The new term, Congress announced who has that. It's over. And so that's, when we talk about someone being a trespasser, it's not because we think that he is personally, it's because Congress has said he's not the president anymore after noon on January 20th. So there's that shift from law to norms, but there's still some norms at that point. As Professor Lawrence said, the military tries not to get involved in things like this. Well, but what if they did? What would we do? At a certain point, the law doesn't have as many guns as the military does, right? And so we're resting on some notions of everyone doing things the way they've always done them. And luckily, it's always worked so far. And I think our institutions are pretty strong. And I think as a result of that, I don't think it will come to that. I think it's a question people wonder about what would happen, but I just can't imagine. I just can't imagine it coming to that.
And another thing to consider is that the president doesn't, if the president starts exercising executive authority, and what do presidents do? They issue executive orders, they appoint officers that have to be confirmed by the Senate. If Trump says, I must remain in power because we can't trust Joe Biden to conduct our foreign policy. Well, how, if he issues, if President Trump were to issue, or then President Trump were to issue an executive order, how is that going to get enforced? The Senate, which already determined that he's not the president, that Joe Biden is the president, they're not going to take any of his nominations seriously. No one will take any act that requires enforcement seriously. So in terms of legal authority, where is he going to go? I mean, the only way he exercises any authority is with military force, right? And like as Professors Lawrence and Kalt indicated, I don't see him having enough there to sustain rule without law, without the courts, without Congress. And anything he might want to do to further his agenda is not going to happen. I do think what we all need to be prepared for, just politically, not legally now, is Trump 2024. And I think if anything, what will keep him from playing any games with remaining in the White House beyond his due is he wants to be president again. And I think we can look forward to 4 years of machine gun tweeting, mocking Joe Biden and his administration at every possible turn. And so his campaign for 2024 has already begun, and staying in the White House doesn't help him with that.
So I really appreciate the points that were made about law versus norm. And also, as you've mentioned already, law versus politics. I'm curious, given what we're seeing, and maybe I don't remember it well enough, but I think back 20 years ago to, was it really that long ago, to the Bush versus Gore litigation. How is it that we haven't aged in those 20 years? But when I think back to that litigation, I remember we were sort of on pins and needles, wondering what would happen, and yet the chaos that I think we're experiencing now I don't remember it to the same extent. And it could just be because, now I'm 20 years older, so I don't remember things so well. But I'm curious, as we're talking about law versus norms, do you see where, as Professor Lawrence was saying, President-elect Biden hasn't had access to funds for the transition team and so forth. Do you think the law will step in? Do you think that we will actually see legal change in response to what we have witnessed in this presidential cycle?
I think very,
I'm
very.
throwing him a curveball, but
No, I think very possibly. You're talking about after January 20th, and depending on what happens in Georgia in part with the Senate races. But I mean, there is, in terms of how much cooperation there will be with President Biden's agenda. But as there was after Watergate, even a longer time ago, in 1974, 1975, a lot of reform in terms of, okay, we have some holes in our system here we need to plug. And I think there's going to be a lot of that. And I think that's a bipartisan thing. That will get agreement across the aisle. And so, yes, answer your question directly, I think there will be changes to try to deal with, among other things, that this transition funding is being held up or can be held up by a single political appointee. That has to change to allow for some smoother transition between presidencies.
And in 2000, the reason the transition was delayed in 2000 was we really didn't know who won. The final margin was 0.009%. Now we're talking about the closest state being about 0.3%, right? So about 30 times that. So we really didn't know who won until the Supreme Court stopped the recount. And so the delay in the transition there was perhaps unavoidable, but they changed it after that, because after 9/11, we recognized one of the things in the transition that's really important is the new administration submits the names of people who need security clearance, and the process of getting someone a security clearance takes a long time. And if that's delayed, then you have precious time from January 20th on, a few weeks, a couple of months, where those people can't get in and they're playing catch up from the get-go, and that's very damaging. But after 2000, we changed a lot of things. So that margin was 0.009% in Florida, and almost 3% of the ballots cast in Florida that year were thrown out, either undervotes or overvotes. People's votes weren't counted because of the technology. So if you have an election that's decided, it's like in a football game. They spot the ball at the end of the play, and it's, you know, within a couple inches here, a couple inches there. They can't be exact, but they bring out the chains to see if you have the first down or not. And if you're just a hair short of a first down, you don't have it. You want to spot that ball as precisely as possible, so that little arbitrary "did you get the first down or not" call doesn't look like you're just sort of flipping a coin to see who's president. So after 2000, the 2002 Help America Vote Act greatly improved voting technology. We don't have, at least for people showing up at the polls, we saw a lot of mail-in votes being thrown out, but we don't have 3% of the ballots getting thrown out. We don't have punch cards anymore. I would expect to see similar debate. I don't know if it'll be as successful this time. It took a couple of years after 2000 to pass that act, but I would like to see more federalization of election administration so that we don't have what we had this time, which was when COVID struck and every state had to figure out how are we going to redo our election system. And they were answering that in the heat of a campaign. And partisan elected state officials were deciding what to do. So you had 51 different answers for how easy is it going to be to get a ballot? How many drop boxes are there going to be? How late can the votes come in? And all these decisions made 51 different ways and challenged in court and being litigated before, during, and after the election. If we had centralized federal administration of those questions, so we had uniform standards guided by best practices instead of by perceived partisan advantage, that would simplify the system. It would make it more efficient. It would make it more reliable, and it would give people more confidence in the system. But only if that federal administration could be set up in a way where it would be independent. And so I think that's what we'll see. We'll see attempts to make more centralized election administration if we can do it in a way where it's politically independent. Because it's not a solution if you say instead of 51 different partisan officials across the country deciding it, the president and his administration decide how we count the votes. That's not an improvement. It would need to be independent.
Another problem that I see with all this is the timing. I mean, I agree with what Professor Lawrence said before. I mean, we all should be looking to President Biden and Vice President Harris come late January. But I given all that's happened already, I think we can expect some effort to dissuade electors from who are on their slate in particular states from voting for them. Just like there was that same effort to dissuade electors from voting for Trump, right? And again, if you remember, there were the ads, Hollywood celebrities. We're not saying vote for Hillary Clinton. We're just saying don't vote for Trump. And if you can, and maybe if we can persuade enough electors, we can get that number down from 270. And there were a handful of electors who did not vote for President Trump, even though they had been. So
I just want to break in there. There were
Sure.
2 that didn't vote for Trump, and there were 5 that didn't vote for Clinton. So all that talk, it motivated more people to not vote for Clinton than to not vote for Trump.
But those individuals were not Trump supporters. The ones who didn't vote for Clinton, right? They weren't Trump supporters.
No, they voted for people other than Trump.
Right.
And the Trump people voted for, one of them voted for John Kasich, and the other one voted for Ron Paul. Yeah.
So my point is that the electors deviated, right? You had a it wasn't many, but it was enough to indicate that this is something that could happen. So I imagine there will be some effort to dissuade Biden electors to vote for Joe Biden. There's a question about electors following the popular vote. No, they're not required to do that, but they can be sanctioned by the state if they refuse to. The constitutional issue in the case was whether they can be sanctioned for refusing to comply with the mandate of the people. they can still be sanctioned, but that they can still vote in a different direction. So that, I'm sure there's going to be and also going back to 2000. I don't know why we keep doing this. It's kind of depressing, but we keep referring back 20 years ago to Bush versus Gore and all that happened there. But at that time, there was an effort in Congress. It didn't go very far, but there was an effort in light of all the controversy surrounding the election of George W. Bush. There was an effort in Congress to refuse the recognition of the election and to say that George Bush is not our president. Again, it didn't go very far. Not many legislators were on board with it, but you might see some of that as well. So between efforts to dissuade electors from voting for Biden, efforts in Congress, perhaps, to argue against recognition of Biden and Harris as president and vice president, respectively, there's a lot. I don't think there's any reasonably foreseeable chance of this happening, but it's just something that we have to go through, and we have to see how it plays out and how rigorous the efforts are.
Right.
And so that my only concern is, and the reason I bring it up is because it would be nice if the time frame could have begun a long time ago, right? Considering that we're talking about inauguration in late January, maybe we should have all these processes taking place in October as opposed to early January, and then we'll have more certainty, especially when it comes to things like funding the transition of the new president who will be displacing the former one. So
regarding the electors, if I could just jump in real quick on that. I mean, let's think about who the electors are. They're partisans. They're Democratic or Republican partisans. So in the state of Michigan, the Republican Party nominates the electors who would serve as electors, and the Democratic Party then elects their own. And those are partisans. Those are like people who go to the convention. Or whatnot, and so it's a great honor to be an elector. So they are partisan people. So it's unlikely. While there will be, you're right, Professor Pachillo, that there will be those efforts, but it's unlikely that many of those people would be dissuaded from their positions, given who they are.
Right.
Yeah. Historically, we've seen maybe one or two people every election. Usually, people who voted for the loser. Not vote for who they're supposed to, as a way of protesting, but not as a way of actually changing the result. We've never had anything like that happen since the vice presidential pick in 1836, which we don't need to get into. But the Supreme Court decision, Chiafolo.
None of us were born then.
True. But the Chiafolo decision didn't talk about what electors can and can't do. It talked about what states are allowed to do. So some states don't put any restrictions on what the electors can do, and they just rely on their partisan loyalty, like Professor Lawrence just described. Others say, well, they can vote for whoever they want, but if they vote for the wrong person, we'll fine them. Supreme Court said that was okay. But some states say, if they vote for who they're not supposed to, then we yank them right out of there and replace them with someone else who will vote for the right person. And the Supreme Court said states can do that too. So it's not an issue. And then in 2000, when there was some protest, they were following the Electoral Count Act of 1887, which I promised before we would talk a little bit more about. And there are procedures in there for disputes. And one of the procedures is you need someone in the House and someone in the Senate before a protest can go forward. And in 2000, a bunch of people from the House protested the Florida votes, but no one from the Senate would join them. And Al Gore, as president of the Senate, presiding over that, said, sorry, you can't have that protest go forward. Another aspect of the Electoral Count Act of 1887 is if the protest does go up, then the House and the Senate both need to vote by majority to not count the votes. And the House is Democratic, so I don't think the prospect of, even if there's a successful protest that goes forward, successful in terms of getting a vote, they're not going to win that vote if the Electoral Count Act is followed.
So we're coming up toward the end of our program, and obviously we have a lot of rich discussion and we could keep going, but I am mindful of time, and I promise that we will conclude hopefully at 8:30. Give us, bear with us if we go a minute or two over. but we've been talking about electors, we've been talking about the partisan nature of electors and so forth. And this I see raised frequently. We saw it in 2016, and then here we're talking about it again in 2020. Why do we have the Electoral College?
Well, in the 70s, the House of Representatives voted overwhelmingly to go to a popular vote for president, and the Senate filibustered it, and that didn't go anywhere. I think the main reason, I mean, there's two questions. Why do we get it in the first place, and why do we still have it? The main reason we still have it is because it's really hard to amend the Constitution. And I think that if it were easier to amend the Constitution, we would have gone to a national popular vote by now. There is the National Popular Vote Interstate Compact movement, where, as we were saying before, the state legislature can choose how its electors are allocated. Someone said, hey, why don't they choose to award the electoral votes to whoever wins the national popular vote? And if enough states do that, then the national popular vote winner will be the president. And we can do that without amending the Constitution. Well, there's some question about whether that complies with the Constitution's Interstate Compact Clause, but the bottom line is that there are a lot of states that have gone in that direction. If they get a few more, if they get some purple states, it's mostly blue states doing it so far. If they get some purple states, if they get enough states where it's 270 electoral votes represented by that, then we will have a national popular vote. I suspect what would happen then is that Congress, recognizing that this is where it's going to go, would say, let's make this cleaner, let's amend the Constitution to have it in a more official way. And then we can do things like defining what the national popular vote is. One nice thing about that is that we could then include people who live in the territories or people who live abroad who currently can vote in ways that are probably unconstitutional. So I think in the next 10 or 20 years, it's I would say not more likely than not, but there's a significant chance that we will, in fact, change to a national popular vote.
Other thoughts on the Electoral College? Because all three of you immediately kind of smirked, and I just
to discuss the Electoral College, I think we have to acknowledge the founders' skepticism of power being exercised by the people. The people were thought of being just as tyrannical as any government official could be. And so the Constitution does all kinds of things, or at least it did in its original form, did all kinds of things to prevent the people from having power and exercising power as a group or in groups banding together, including the Senate. How were senators originally chosen? They weren't chosen by the people. They were chosen by the state legislatures. The federal judges have never been chosen by the people of the United States. And I wonder if we ever do go to a popular vote for president, are we going to have such confidence in ourselves that we would then say, you know, it's time that we had a popular vote to either elect or recall individual members of the federal judiciary or of the U.S. Supreme Court or of the Court of Appeals. I think that's unthinkable. That we would, because I think that for the most part, the American public accepts that, you know, the judiciary is off limits. Ironically, in many of the states, Michigan included, judges are popularly elected. Chief Justice Bridget McCormick just had to undergo re-election, right? Not reappointment, re-election by the people of the state of Michigan. If we ever went in that direction federally, I think there'd be a lot of opposition to that sort of thing. So to make the case for the Electoral College, it would be that there's something fundamentally good about inserting some institution in between the people and something like the presidency. What would be interesting, and I think something that I'd support is perhaps like they have in many states now, maybe there should be a recall possibility. California successfully exercised years ago, leading to Governor Schwarzenegger. Wisconsin tried it, didn't work out to recall I forget his name, the person who was then the governor. But perhaps we could have a popular, if we don't have popular election of the president, maybe we can have popular recall of the president. So lots of interesting things can be tried. But I do think if we move away from the Electoral College, it would lead to kind of a rendering of many of the smaller states as having virtually no role to play, and because presidential candidates just wouldn't be campaigning there. Many parts of the country would just be ignored in favor of large population centers.
So as we're coming up on the end of our time, first of all, I thank everyone again for joining us, and I especially thank again Professors Kalt and Lawrence and Pachillo for giving their time and their thoughts, right, their energy and so forth. So I was thinking, how to conclude. What is, and this would be for each of you, and so you have like a minute or so to answer, but between now and January 20th, what is the one thing that you're paying closest attention to? Or what is it that you would encourage us to pay attention to between now and January 20th, right, as we think about this election debrief?
I'll go first. 1 minute starting now. First thing I'm going to look at is all of the things that we usually don't pay attention to, that we take for granted, but that will suddenly become very important. The states certifying the results. 8 states have certified so far, the rest in the next few weeks. The Electoral College voting on December 14th. Congress counting those votes on January 6th. I'll be paying very close attention to that. I'm also going to be looking at the transition issues that we've talked about here, because it's a real problem. It comes at a real cost to the country. And I hope that we can reach some consensus, if not what should have happened this time, at least what we can do better next time, so that some good government reformers in Congress can pass some legislation to make it better next time, just like we fixed the transition after 2000.
I guess since we're going alphabetical order, so I would say those events that Professor Kalt's mentioning as well, including here in Michigan after the events of yesterday, the state canvassing board, which is going to be certifying, and that's a 2 Republican, 2 Democrat committee as well. And so those are the things we would never have paid attention to. But that vote is coming up in a week or less than a week, and then going on. So those things. I guess also I would just say, and it's a good audience to whom to say this as lawyers and law students, most of you alums, is the importance of an independent judiciary and the role of the judiciary really in this process. And I've long felt, and I'm a constitutional law professor and scholar, and I believe in the strength of the Constitution to allow us to weather difficult times. And we've weathered very difficult times through our history, numerous times, Civil War, and certainly this is something as well. And the Constitution has allowed us to pull through, and a large part of the success is the independent judiciary and the fact that the courts, that for these sorts of charges and claims to go through, there has to be evidence and whatnot. So I'm confident that we will come through this, and we have a lot of work to do, but I'm confident that we'll come through this in fine shape.
The first thing that came to my mind, I'll be focusing on the release of the Kraken. That's first. Secondly, I will be focusing on what's going to happen with Georgia and the 2 Senate races there.
Yeah.
If I'm praying to God for anything between now and January 20th, it's that election go much more smooth than in many of the states in terms of how ballots were challenged, how ballots were counted. I mean, just in the recount in Georgia, it's never good. I mean, it's bound to happen, right? It's bound to happen that votes are overlooked, that ballots are forgotten or lost. But I think you had 3 separate instances during the Georgia recount where thousands, stacks of thousands of ballots were uncovered, and Trump was able to make some small gains, not really cutting in significantly into Joe Biden's lead, but he did make some gains. So I'm hoping that that the election can go smoothly with both races, so that inevitably it's going to be close. There will probably be a recount, maybe an audit, and it would be nice if the Senate could stabilize. I think that would be an inherent part of a new presidency. To usher in a new presidency would be a stable House, which we appear to have, and then a stable Senate as well. You stabilize Congress, I think that'll lead to a more stable situation with the presidency.
Well, thank you all. Thank you everyone for joining us. Thank you again to Professors Kalt and Lawrence and Pachillo. Thank you to our DC alumni group, to all of our alums, students, and friends of MSU Law. On behalf of everyone, I bid you a very good night, and we'll look for you virtually on January 20th. We'll see what comes next. Have a good night, everyone.